number 7, matter of Endara-Caicedo versus the New York State DMV. We'll take a moment to allow counsel to collect their belongings. Counsel?
Thank you. Good afternoon. Marika Meese for petitioner appellant Pedro Endara-Caicedo. I would like to reserve 2 minutes for rebuttal, please.
You may.
This case involves whether the phrase such chemical test as used in VTL 1194-2C can have an entirely different meaning than that phrase's use in 1194-2A and
Counsel,
2F.
can I ask you something? Just so I'm clear, and I really don't completely understand this. So in a situation like this, and we'll just use a hypothetical, where someone's pulled over and there's a reason to believe they're intoxicated, they're going to be arrested, right? And the procedure, as I understand it, on the administrative side, forget the criminal side, is the license of that driver suspended at the time of arrest pending suspension from a hearing?
Correct. It's immediately suspended if upon arrest, and then there is an administrative hearing at DMV where if the prongs are met and followed, then the revocation can happen.
Okay, understood. So let's say now it's 2 hours later when they ask for more than 2, when they ask for consent and it's refused. If we were to adopt your rule, and that's not usable, let's call it, at the administrative hearing, is the license not capable of being suspended at all then?
In the first instance, upon arrest,
Yeah.
I think no, because, well, perhaps initially, but when the person would go to the refusal hearing, they would then prevail because the refusal not made within the 2 hours does not fall in the statutory
So
scheme.
even though it's
So they would win.
clearly over 2 hours later, let's say it's 3, not close, then your position would be your client's license could still be suspended pending a hearing, or they couldn't use that in evidence?
I believe so long as there's still a proper arrest on reasonable grounds and a person is arraigned, the license could be suspended until they went to that hearing. But the cutoff point of 2 hours is for the refusals, which is tied to the deemed consent provision. So that reliability concern that governs both criminal and administrative proceedings applies equally, and the statute has to be interpreted the same in both contexts.
Hasn't the legislature made it abundantly clear to treat the criminal and the administrative proceedings separately?
They're separate venues, but they serve the same goal. The very purpose of the deemed consent provision was to get people to blow so that they could secure convictions. And so
Well, perhaps it was a public safety argument.
And well, the legislature set a bright line rule of 2 hours. There's a 2-hour period when you are deemed to have consented to a breath test. If during that 2-hour period you withdraw your consent, that is exercising the right to refusal. It is a term of art that has special meaning within the context of this statute.
In criminal cases.
In both cases. When you do that, then the consequence is that your license is revoked.
But
When
under
you-
1194-2C, there are specific and limited considerations, none of which talk about a 2-hour rule.
All of which say such chemical test, the exact same phrase that is in provision 2A, which limits the statute to 2 hours, and that is in 2F, which limits the statute to 2 hours, as this court held in Odom. There cannot be a refusal after 2 hours under this statutory scheme. It doesn't mean that the person cannot still be prosecuted under the impaired provision or the common law provision, and if a prosecution were
So what's the
sustained.
purpose of the 2-hour rule in the context of a license revocation hearing if your license is, you're deemed to consent as a condition of your license? What would the purpose of that rule be?
You're deemed to consent as a condition of your license, but only during that 2-hour period, because the legislature, in enacting the deemed consent statute, recognized that at the time, they thought that drivers had a right to refuse the test. So whether or not that's constitutionally valid today, at the time the statute was drafted, they balanced the concerns with trying to curb drunk driving while also taking into account the important rights of motorists. A 1-year license revocation based on declining a test that you are not required to take, and a test that might indeed be unreliable and be a false positive, should not result in a severe sanction of a 1-year revocation and a $500 penalty. And that was a bright line rule that the legislature drew, and that should be honored by this court. The plain language of the statute and the rules of statutory construction, as well as its history, all show that both provisions equally apply this 2-hour limitation.
So counsel, just to be, I'm over here on the screen. Hello,
Yes.
Happy New Year.
Hi.
Yes, hi. Just to clarify your position, the position is that to the extent that what the statute does in the administrative context is allow for revocation regardless of any eventual determination of guilt in the criminal context, that there is where this rule cannot apply, right? Because the understanding was always about the constitutionality of the rule. But of course, that a license could be revoked pursuant to the statutes otherwise, if indeed the criminal case is successful.
Correct.
I just want to clarify where you are. You're not saying that the license can never be revoked.
Absolutely not, Your
Your
Honor.
point is it can't be revoked because an individual in that 2-hour, post the 2-hour window chooses not to take the test.
Absolutely.
But that's not the punishment the legislature intended.
Exactly.
But post the 2-hour window, if they're otherwise established to have violated the statute subjecting them to revocation, well, so be it, but not. I just wanted to clarify your position because I wasn't so sure based on something you said a minute ago.
Outside of 2 hours, if a person can still be prosecuted criminally, they just can't be prosecuted under the per se sub 2 division, which requires a breath test. If they're still prosecuted and they did not blow, they can still be convicted and their license can still be suspended. The punishment envisioned in the revocation proceeding in 1194-2C only applies where a person has exercised their right of refusal and withdrawn their deemed consent, and that period is undeniably a 2-hour period.
Can I see if you have the same statutory development understanding that I do? So in 1941, the ability to take a test, right, chemical test for alcohol came in.
Correct. Governed by 2
And
hours.
it had a 2-hour rule, right?
Yes,
And there was no license, suspension, revocation, anything like that at that point?
correct. There was nothing.
Okay. In 1953, the legislature added the deemed consent in conjunction with license suspension.
Correct. The
And so-
the revocation was a punishment for withdrawing your consent.
Right. So in 1954, let's say,
53, I think, yes.
well, right, but moving ahead a year, so we have no worry about when the statute became effective. I mean, I could look that up, but let's not. Let's move to 1954. If you were stopped, a test, and you refused a test, 6 hours after your arrest, your license could still be revoked.
No,
Why not?
because the provision was always read to be bound by the same 2-hour rule. Even though that was in a different statutory provision, they were read together.
Like, there's no such chemical test language there.
But DMV itself read it that way for 50 some odd years until their policy change in the 2012 memo. Everyone understood that the refusal was a term of art only in context of the deemed consent provision, and that it only occurred when you withdrew the deemed consent during that 2-hour period.
Okay, so you're saying from the period from 1953 to 1970, I think, is that right?
Until 2012, when the DMV changed their policy.
No, I didn't finish my question.
I'm sorry.
In 1970, there's then a recodification. Yes?
Correct.
Okay, so let's take the period from 53 to 70. At that point, the argument you're making is not based on the statutory text, it's based on everybody's understanding.
Yes, it's
I mean,
based
You're not
on,
pointing to that same such chemical test language because that didn't exist then.
correct. The such chemical test language came in the final moving of all these parts of a statute that had always historically been read and understood together by DMV and by courts. They put them all in one place, and that's why it was deemed an inconsequential change, because it was the same historical reading of this statute as it had been read, even though in disparate parts. And this is a continued reading that we're urging today, and it's the reading that makes sense based on the statute and the construction of.
Thank you, counsel. Counsel?
Thank you, Your Honors. May it please the Court, Philip Levitz for the respondents. The vehicle and traffic law requires the DMV to revoke the driving privileges of a drunk driving suspect who refuses a chemical test irrespective of the time of refusal. Endara-Caicedo's request to read a 2-hour limitation into the license revocation requirement fails for two fundamental reasons. First, it's inconsistent with the language, structure, and history of the statute. And second, the 2-hour rule is a rule of evidence for criminal trials with no application to administrative license revocation, as Your Honors were suggesting.
Counsel, I'm sorry to interrupt you there, but do you agree with your colleague's assessment of how this was applied before the merger of the statutes?
Of how it was applied?
Yeah, that this changed in 2012, essentially.
Well, it is true that DMV issued an opinion in 2012 after, for the first time, doing a formal examination of the statute and concluding that the statute required the reading that we're presenting today. Let me explain the basis for that reading.
No,
So
but before that, how did you read it?
there was a period of time when we read the statute, well, when a 2-hour rule was applied as a practical matter. That is what DMV did before 2012. But again, that was before any formal examination of the statute, and it was based on really a different situation, a different practical background than we have now, because way back when, there was a concern that, you know, after 2 hours you might not get the best evidence. That's the reason that the 2-hour rule was created in the first place. Later, as this court recognized in the Atkins case, in understanding that you could get relevant evidence after 2 hours, the DMV also recognized that you could get good evidence after 2 hours, and if you could use the evidence after 2 hours in a criminal case, certainly it shouldn't be a bar to its relevance in the rule that you need to revoke for for test refusal. So again, let me get into the history of that.
Those are pretty good policy reasons, but can you deal with exactly where counsel started, which is
Right.
the statutory language?
Absolutely, and that's exactly where I wanted to go.
It uses such chemical test over and over and over.
Right.
What is the best argument you can give us for why such chemical test means something different in different sections?
Right. Well, the history is actually absolutely clear, and Your Honor, Judge Wilson, you were getting at it. Let me explain. The vehicle and traffic law expressly provides in subsection C, 1194-2C, that the determination of whether a driver's license will be revoked for test refusal shall be limited to 4 issues, none of which includes a 2-hour limitation, and none of which is disputed here. So the language of the statute requires revocation in this case. So let me talk about the history. Endara-Caicedo contends that the phrase "such chemical test" in the license revocation provision, subsection C, incorporates the 2-hour limitation from the separate deemed consent provision of the statute. But as Judge Wilson, you were getting at, the 2-hour limitation was not even in the same statutory section when the license revocation provision was enacted with that "such chemical test" language. That "such chemical test" language has never changed in the license revocation provision. It's always been there from the beginning, and when the statute was enacted, there was no 2-hour rule in that section. So as you were getting at, there's simply no way to read into that section a 2-hour limitation that wasn't there. When the legislature later consolidated the 2-hour rule and the license revocation provision in the same statutory section, it gave no indication that it now intended to apply the 2-hour limitation to the separate administrative license revocation requirement. It's a fundamental canon of statutory interpretation that such legislative silence does not imply an intention to significantly alter the mandatory revocation scheme that had always existed in the statute. And it's the burden of a party contending that legislative action changed settled law, here Endara-Caicedo, to show that the legislature intended such a change. Well, Endara-Caicedo has offered absolutely no evidence to meet that burden. So second, it would make no sense to read a 2-hour limitation into the administrative license revocation requirement. The 2-hour rule is an evidentiary rule intended to ensure that the chemical test evidence introduced in criminal trials was collected recently enough to be
Let me
probative.
stop you just for a second. A problem with saying that it makes no sense is the department did that for a few decades.
Again, it was before they examined the statute, and it was at a different time when, as I was talking about, there actually the whole reason for the 2-hour rule in the criminal context where it started and where it should be limited, and it, actually has always been limited in the statute, is a concern about whether you'd get probative evidence after 2 hours. Okay, that was a concern that technology has changed over time. It's a concern that simply doesn't apply today because technology has improved and you can get good evidence after 2 hours. Now, that rule still exists in the statute as sort of a bright line rule for criminal cases, that unless you consent to use of the evidence after 2 hours, it's not going to be admissible. But if you consent, what this court held in Atkins is absolutely you can use it because it could still be probative. In any event, again, once DMV examined the statute, this is exactly the conclusion it came to in the modern context. And as a majority of this court recognized in Odom, the 2-hour rule has no application to administrative license revocation, which is a required administrative penalty for chemical test refusal, whether or not the driver is ultimately criminally convicted of drunk driving. Let me also talk a little bit about, again, how to understand this statute in the context of the legislative intent and the public policy at issue here. Your Honors, we're talking about the public safety context in which this administrative scheme was created. That's really important here. Applying the 2-hour rule to the administrative license revocation requirement would contravene public policy and legislative intent. The legislature and the Court of Appeals, this court, repeatedly have made clear that administrative revocation of driving privileges was intended to be an automatic penalty for drunk driving suspects who thwart investigation of drunk driving by refusing chemical tests. It's undisputed here that the license revocation requirement was designed to enable the authorities to deal effectively with the scourge of drunken drivers, encouraging this is language from this court in the Kraft case and the Washington case, encouraging drunk driving suspects to consent to chemical tests and revoking their driving privileges if they refuse. Giving drunk drivers a free pass for refusing the test based on the mere happenstance that they refuse more than 2 hours after their arrest would directly contravene the legislature's critical public safety goals. And giving drunk drivers that free pass is especially problematic because a refusal after 2 hours now cannot be used against the driver in the driver's criminal case under this court's decision in Odom. Thus, without the administrative sanction, the driver might escape all consequences for the test refusal and for driving drunk.
Thank you, counsel.
Thank you, Your Honors.
Counsel, your rebuttal?
Thank you. Whether or not the phrase such chemical test existed in the statute in the 1970s, my adversary has admitted, and it's clear that DMV interpreted this statute to limit refusals to 2 hours from inception until its policy change in 2012. What is important is to look at the 2012 memo, because the rationale DMV used was looking at lower court cases that were holding after Atkins that refusals would be admissible after 2 hours in criminal proceedings. They reasoned that if a blow could be admissible after 2 hours, as Atkins held, so too should a refusal. Those cases are now explicitly overruled by Odom. Odom held that after 2 hours, a refusal cannot be admissible in criminal proceedings, and therefore DMV got it wrong. And this court has made that clear in Odom and in the statutory construction.
Counsel, I'm sorry, over here.
Yes.
One of the things I'm struggling with, and maybe some others from the questions, Odom is clear, and it was a criminal case, and there are certain requirements in criminal prosecutions and levels of proof and protections that are different. And what I struggle with is, this is an administrative proceeding, and granted a very serious one, but not a criminal proceeding, where because of 1 minute difference, the quantum of proof in an administrative proceeding goes from 100 to 0. And because you're asked to take this test at 2 hours and 1 minute, someone who was arrested and meets the other criteria under the administrative provisions now gets their license back. And,
Well,
you know, we don't have to go through the cases that we've had and the cases below that address the serious nature of this problem.
Well, the concerns in the administrative context are equally serious. The right to drive is something the legislature
But you
valued.
can't, I think you're on weak ground if you're arguing the concerns in having your license revoked is the same as a criminal proceeding. So what else is there?
Well, as well, Judge, if the DMV's position is urged, then police will actually be disincentivized from timely gathering this evidence. Under Atkins and other cases, all the police need do is request the test be taken. If they obtain that refusal within 2 hours or the consent within 2 hours, it doesn't matter whether the test is ultimately given at 2 hours and 1 minute or not. And
So should there be a
is-
good faith reading in there? So if there was no there's no way in good faith to get this done, should they examine that?
I think the occasions where that would occur are extremely rare. There are Spanish-speaking videos available at most places where DWI proceedings are held, where they could easily obtain the consent or the refusal within the time period of 2 hours. And having a bright line rule that's enforceable for motorists, for administrative law judges, for police is important. And it's a balance that the legislature struck. If they wish to change it, they can easily amend the statute, but the statute as written is limited, and the 2-hour standard applies both in criminal and administrative proceedings.
But that's not what the legislature said. You can't read the legislative history and support the conclusions that you want to support.
I think you can, based on the plain language, based on the use of such chemical tests, based on its consistent interpretation until 2012 as limiting it to 2 hours, and reading the statute cohesively and comprehensively as the rules require.
Thank you, counsel.